Let's start with the Fair Act. The Fair Act was a law passed by the City Council. And what it says is that landlords real estate agents cannot collect a fee or commission from a tenant. That is the core of the law. And right there, it's been confusing. The headlines, press have been saying, no more commissions, or agents can't collect commissions from tenants and so on. And that's not the case. And that's been really confusing to people. So to be clear, yes, you can collect a commission in a leasing transaction. You as a landlord's agent cannot collect a commission from a tenant, but a tenant's agent can continue to collect from a tenant. A landlord could pay a tenant's agent, and certainly a landlord's agent can collect a commission from the landlord as well. So there's been a lot of confusion there. We as being inclusive of REBNY, we've asked for some guidance from the Department of Consumer and Worker Protection, which is the agency, the New York City agency that oversees and enforces that law. And we've been asking for guidance, and it's dribbling in. And we share that with you. We share that with the REBNY members as that comes in. We've done FAQs and so on. And again, feel free to call me on the legal line to the extent that you have questions. We're happy to answer.
Well, the intention behind that was, or at least what the City Council proposed or said, Cheose and Gary and I were there because we testified, and there were a lot of agents there. They thought that would mitigate the expenses for tenants. They get rid of the broker's fees, which it hasn't done. And so I think it's a situation where it's a very confusing way to do business, and they've convoluted it and probably made it worse. And it's going to end up costing tenants more money over time, is what we've concluded. Fortunately, nobody listened to us, Gary, at that when we were testifying.
We tried. I mean, look, unfortunately, the City Council cares more about optics than they do about impact. And in their own papers, they said rents are likely going to go up as a result of this law. So to go out there and say we're trying to deal with affordability, yet admit in their court papers that that's not going to happen, it just shows you this was all about going against the brokerage community, and basically vilifying us for stuff that we don't have control over. If you understand, like pricing, we have nothing to do with how expensive it is. Union labor, construction costs, real estate taxes, insurance, regulations. So in essence, they look to blame the broker. And if you see what's going on right now, co-broking has almost been eliminated, which is very difficult. And the biggest thing is they campaigned on the theory of the fee, but behind the scenes, without talking to any of us, they changed it to a no advertising policy, right, which has taken out all transparency from the real estate market. Tenants have no idea you could find better deals with a broker than you can publicly. But since Cheose and everyone else said no broker fees, people don't even want to see those apartments. So they'll end up renting a more expensive apartment and then staying for a few years and getting increases on an already increased rent. So every year they stay there, they're paying a fee. So 3 years, 3 fees, plus 5 to 8% increases. It did not help tenants.
It didn't help tenants. And I think the other thing that Cheose was on record as saying was that, why should we pay an agent? All they do is open the door. And he was on video saying that. So, look, I have to believe that they have good intentions. Unfortunately, we have to talk to each other and try to help to make the system functional and effective for everybody. So we have to see how this all pans out a bit.
Well, the unintended consequences we knew were intended.
Yeah.
That's the unfortunate part.
It is, unfortunately.
Just a couple of other points. REBNY and the New York State Association of Realtors are appealing. They wound up suing the City Council. They were unsuccessful on certain points, but there are a couple of points that are still outstanding. So there is still an ongoing lawsuit,
a chance,
with respect to, and it's being heard by the Second Circuit Court of Appeals, the federal court, which is one of the most powerful courts in the country. So there's still a chance there.
Neil has hope, everyone.
I do have hope. I always have hope.
Hope's a good thing.
We need it. In today's world, we need it.
Absolutely. A couple of other points about the Fair Act. The Fair Act does not prohibit dual agency, and I think that is an important point. But interestingly, they've interpreted it to focus more on the individual agent. Dual agency, as everyone knows, it's really at the broker level. So right, if Brown Harris is representing a buyer and seller at the same time, that's dual agency. It's not really about the agents. With respect to the Fair Act, they actually do focus on the agent. And so importantly, we are suggesting that if a Brown Harris agent, for example, takes a listing from a landlord, that you utilize dual designated agents, so that that agent is representing the landlord, and then another agent from Brown Harris could represent the tenant. And according to the interpretation, by virtue of us being clear about
Who's representing who?
exactly, that's really helpful, and that would be permissible. So really importantly, the use of the agency disclosure form now is extremely important, to be very clear that I'm representing you, the landlord,
Yeah.
and so on. And then the use of fee agreements and being very clear, yes, we represent you. This is how we're going to get paid. And I'm suggesting that agents and brokers be very clear about who they're representing. I think designated agent is a helpful thing to do that. So I'm going to recommend
That shows you how far we've come, the fact that we're excited about those agency disclosure forms. And, you know, when they first came out, everybody was like, what does this mean, you know?
Well,
But
so that was a key distinction, because if you want to be represented and you happen to work with an agent that the same firm has a listing, to have almost prohibited that wouldn't have benefited a tenant
No,
in any
of
way, shape,
course
or form. So
Yeah.
to allow them to choose representation, and granted you used the proper form, but that was a key distinction, because the way it first came out, it was not clear until you guys got guidance.
that's right.
Yeah,
That's
it was definitely not clear
At
and it
all.
was concerning. So I would recommend highly do that. And then additionally, given where we are, I've been doing this 30 years, and I would say I've seen more changes in the last 2 years. But now the need for agency disclosure and for fee agreements, to make sure that you have a fee agreement with everyone that is agreed to pay you. So if you're representing the buyer, for example, but a seller has agreed to pay you, make sure you as an agent have an agreement with that seller as well. You have your buyer agency agreement, your buyer representation commission agreement, whatever you want to call it, but you need to make sure that that's the case.
Yeah, because we've seen, Gary and I were talking about this, you see people missing out and not being able to collect the money that they've earned because they didn't have the agreements in place. So you really have to make sure to do that. And if you don't feel comfortable with them, which I get it, they're a new form, you know, talk to your executives, your managers, whoever's there. Neil, he'll happily explain it to anybody. So
7 days a week, 24 hours a day. Call
yeah, Neil. Yeah, give him your cell, Neil.
Yeah, there
But
you go.
you know, it would be helpful, I think, if you explain to people conditioning, because I think there's so much confusion as to that word and what it means and how that it plays with being able to represent a tenant, because that seems like such a strange term.
Right.
Because ultimately you can't work with me technically unless you sign an agreement, and everyone's like confused as to, well, is that conditioning? The answer is no, it's how you phrase it. So it might
Right.
be helpful to give
That's
people
it.
some clarity on
Yeah,
that, because
sure.
that's where I think the most confusion comes from.
Right. So this law, I mean, I will say this publicly, was not well drafted. We tried, but we unfortunately our voices were not heard. So what Gary's referring to is the law. The Fair Act says that an agent can't condition the showing of a property on hiring them. That's basically what it says. And so if you're an agent and a tenant comes to you and says, can you show me properties? Instead of saying, well, I can show you this property, but you have to engage me. I recommend saying to them, look, I can show you lots of properties. If you engage me as your agent, I will endeavor to show you lots of properties. And by the way, I get paid for that. And if you really think about what the law says, this idea of conditioning, well, every relationship is conditioned. I show you a property, I'm going to get paid.
Of course.
Right. So that's confusing in its own right. But this idea of expressing to a tenant, which I think is a good idea anyway, is to express to them, look, I'm your agent. I'm going to try to find you the best property possible that fits your needs. And it's not limited to this one property. So someone comes to you and says, Gary, I can show you this property, but you have to pay me. That is not what we
Well,
want.
it's
you to
choosing
do.
your words carefully and
Exactly.
making sure you're explaining to someone that this is not a forced relationship. You have complete control if you want to enter
That's
into
right.
this relationship. And if you want to, I'm here to help you.
Right.
But I think a lot of people get very caught up in that word and what it means, because like you just said, everyone is paying for some service
Yeah.
somewhere along the line. So I think they really need to focus in on that, because the Department of State, they're out there.
Yeah.
You know, testing
Right.
people, calling people, and looking for people to make mistakes on what we all know is a very unclear piece of legislation. So it's very critical to not be in that circumstance. I think with the first time it's a $500 fine or something along those lines. So they can add up, and you don't want to put yourself in the middle of an uncomfortable situation.
Yeah.
Such a good point.
I agree. And I go back to still the use of the agency disclosure form, fee agreements, and you'd be surprised how this yesterday, I think I got a phone call, complicated matter, but the first question I asked was, did you give an agency disclosure form? Do you have an agreement? And the answer was no. So I was talking to a buyer who was confusing about who's representing the buyer. And I said, well, just let that buyer's broker know that
Yeah.
you didn't give any disclosure form, you did not identify who you're representing, and you don't have a fee agreement. Under what circumstances does this buyer's broker think that they have the right to a commission? So it was a little bit more complicated than that, but just it's amazing to me that I ask that question all the time, and you'd be shocked at how.
I think because it's, you know, agent, if you feel uncomfortable a little bit, agents sometimes feel a little bit shy or uncomfortable because you're asking to get paid, so, but we have to have those conversations. You're giving, you're providing value to people, and you deserve to get paid for your time. So,
but it also looks bad when the law is what it is now, and on buy-side agreements, disclosure. If you're not fully familiar with the ins and outs of all these laws, ultimately you get uncovered as an agent who's not really paying attention to what you are doing in the industry, because if you go to somebody else that is buttoned up, and I know Neil about process and procedure, like he'll talk to that till the day is done. This is where agents run into problems where they don't spend enough time understanding something. Oh, it's a good friend, it's a referral, et cetera, et cetera. Well, the good friends and referrals are the first people who land up not paying, because they find a loop, and maybe they'll blame their attorney. Well, where's my buy-side agreement? So you really do need to spend the time learning all these things. And if you're not comfortable, whether it's through REBNY or through your firm or other places, it's critical to understand, because your license is the most important thing you have. And if you're going to ignore the law, you're eventually going to lose your license.
Yeah.